That's right.
Assalamu alaikum and Bismillah ar-Rahman ar-Rahim. Thank you all for joining us again. My name is Safura Khan, and we at Cornerstone Law Services are excited to bring this series of financial and legal tools for the Muslim family. We understand that it can be confusing and intimidating when we think about finances and legal services. So Hani and I wanted to offer free webinars to our community so we could educate members about the tools and services that are out there and offer you all a chance to ask your questions in a comfortable space. We will be bringing experts in different areas from time to time, and we want these to be interactive sessions where you can ask questions that are important to you, and you let us know what you want to learn more about, and we'll try to accommodate everyone. And so I'm also obligated to mention that these webinars are not intended as legal advice, but for educational purposes, and to please reach out to legal professionals so they can make a plan that's specific to your situation. So we are going to be presenting the tools that are available so that you and your family can choose the best ways to use them or not for your family. And this way you can have a conversation with your loved ones or any legal professionals in order to optimize your finances for you. So in future sessions, we'll talk about guardianship of minors, which is, you know, what you do in case something happens to both parents to ensure that it's a smooth transition to the people you choose to take care of your children. We'll cover power of attorney, healthcare directives. We'll cover insurances, tax planning, investments, and a lot more. But today we're going to talk about, oh, and just to mention, last time we discussed wills, specifically Islamic wills. And today we will talk about what is a trust and the difference between wills and trusts. So I will let Hani enlighten us on that.
Thank you, Sephora. So I want to get right through it, right into it. So the key differences between wills and trusts, you know, when discussing estate planning, you know, a will is what most people think of first. So indeed, wills have been the most popular method for passing on assets to heirs for hundreds of years. But wills aren't your only option. And if you rely on a will alone to pass on what matters, you're guaranteeing your family has to go to court when you die. In contrast, other estate planning vehicles such as trusts, which used to be available only to the uber wealthy, are now being used by those of all income levels and asset values to keep their loved ones out of the court process. But determining whether a will or trust is the best for you depends entirely on your personal circumstances. And the fact that estate planning has changed so much makes choosing the right tool for the job even more complex. So here are some key distinctions between wills and trust you should be aware of. So when they take effect, a will only goes into effect when you die, while a trust takes effect as soon as it's signed and your assets are transferred into the name of the trust. To this end, a will directs who will receive your property at your death, and a trust specifies how your property will be distributed before your death or at your death or at a specific time after death. This is what keeps your family out of court in the event of your incapacity or death. Because a will only goes into effect when you die. It offers no protection. If you become incapacitated and are no longer be able to make decisions about your financial and healthcare needs. If you do become incapacitated, your family will have to petition the court to appoint a conservative or guardian to handle your affairs, which can be very costly, time-consuming, and stressful. With a trust, however, you can include provisions that appoint someone of your choosing, not the courts, to handle your medical and financial decisions if you're unable to. This keeps your families out of court, which can be vital during emergencies when decisions need to be made quickly. Because as you know, court is a very lengthy process. The property they cover, a will covers any property that is only owned in your name. A will does not cover property co-owned by you with others listed as joint tenants, nor does your will cover assets that pass directly to a beneficiary by contract, such as, for example, life insurance. So trust, on the other hand, they cover property that has been transferred or funded to the trust, or where the trust is the named beneficiary of an account or policy. So that said, if an asset has not been properly funded to the trust, it won't be covered. So it's critical to work with a family protection lawyer to ensure that your trust is properly funded. And what I mean by funded is meaning basically transferring all your assets from your names into the name of the trust. So if you have a deed, the deed of your home should be transferred from your name or your spouse's name jointly into the name of the trust. If you have a bank account, you have to transfer the bank accounts into the name of the trust, and the same thing with businesses. You know, because unfortunately, many lawyers and law firms set up trusts, but don't then ensure your assets are properly retitled or beneficiary designated. And a trust does not work when your family needs it. You know, if you only have a trust and have not done the funding, have not transferred your assets into the name of the trust, then really it's a waste of paper. It does not work. It's going to fail when the time comes, because the only way to avoid probate is making sure that you have your property basically, and I mean about, when I'm talking about your property, I mean like real estate, is named in a trust instead of named in your personal name. So, you know, we do have systems in place to ensure that transferring assets to your trust and making sure they are properly owned at the time of your incapacity or death happens with ease and convenience. How they're administered. In order for assets in a will to be transferred to a beneficiary, the will must pass through the court process called probate. The court oversees the will's administration and probate, ensuring your property is distributed according to your wishes with automatic supervision to handle any disputes. So as we mentioned last time, the probate process is a court process, is a very time-consuming process. It's very expensive. On average, it costs 5% of your gross estate, and it's also is a public proceeding. Your will becomes part of the public record upon your death, allowing everyone to see the contents of your estate. They see who your beneficiaries are, what they're gonna receive, where they live at. So unlike wills, trust don't require your family to go through probate, which can save both time and money. And since the trust does not pass through court, all of its content remain private. So you just have to do your trust administration with your law firm, with your estate planning lawyer. Everything becomes private as soon as the trustees decide to kind of take care of the trust administration. How much they cost. So wills and trusts do differ in cost, not only when they're created, but also when they're used. The average will-based plan can run between $500 to $1,500, depending on the options selected. An average trust-based plan can be set up for $1,500 up to $5,000. Again, depending on the options chosen, how advanced, if we're including any irrevocable trust or asset protection trusts. So at least on the front end, you know, it seems that wills are far less expensive than trusts. However, wills go through probate, where attorney's fees and court costs can be quite very hefty, especially if the will is contested. Given this, the total cost of executing the will through probate can run as high $10,000 to $20,000 or more sometimes. So even though a trust can cost more upfront to create than a will, the total cost once probate is factored in can actually make a trust the less expensive option in the long run. So during our family wealth planning session, this is our process when we meet with our clients for the first time. We'll compare the costs of will-based planning and trust-based planning with you, so you know exactly what you want and why, as well as the total costs and benefits over the long term, so there's no surprises. So as your family protection lawyers, we offer expert advice on wills, trusts, and numerous other estate planning vehicles. But we go beyond that as well. And when you become one of our clients, we give you access to our proprietary system, which is basically your family wealth inventory and assessment e-portfolio that has AI technology built in that helps you or helps us carefully, well, helps us and you carefully analyze your assets, both the tangible and intangible assets, where the system automatically identify gaps in your financial and legal portfolios and make recommendations to fill in these gaps to help you come up with like a holistic financial real estate and estate planning solution that really offers maximum protection for your family's particular situation. So these used to be available only to the uber wealthy, but we are now making it available to those of all income levels and asset values to keep their loved ones out of the court process. So you can contact us today to get access to this and get started and identify the gaps in your financial portfolio to get more financially organized than you've ever been before and make all the best choices really for the people that you love the most. So we're very excited to share this AI technology that we have customized for our clients, Sephora. And, so I'm gonna move on right now into how do trusts affect your taxes. So, many people come to us curious or confused about trusts and taxes. So in today's webinar, we're going to sort it out and clarify things for you. There are two types of trusts, and each have different tax consequences. Revocable trusts, which are the far more commonly used trusts, have no tax consequences whatsoever. And this is one of the biggest misconceptions. The revocable trust, it's not an asset protection. Just because you have a revocable trust, that does not mean that you're protected from lawsuits. This is a lie, basically this is a misconception. It also does not it does not have any tax consequences, the revocable trust itself. So a revocable trust has your social security number as its tax identifier. And it's not a separate entity from you for tax purposes. So when you have your trust, nothing changes as far as the way you file your taxes. Everything remains the same. It is a separate entity from you for purposes of probate, meaning if you become incapacitated or die, your trustees can take over without a court order. And this is a plan, is to make sure that your trustees take everything as easily as possible, avoiding this horrible court process called probate, and keeping your family out of court. But until your death, it is treated as invisible from a tax perspective. And I'm not a CPA tax lawyer, but we do have tax and CPA lawyers associates in our firm that basically they can guide you through the tax implications and explain, how at the time of your death, if your irrevocable trust provides for the creation of irrevocable trusts, then the tax implications will shift. So when you have an irrevocable trust, that's a second type. Irrevocable trusts, they're either created, during life or at death through a revocable living trust, or through even a will that creates a trust. The trust has its own EIN, or employer identification number, also called a TIN, tax identification number. Generally, it pays income taxes on income earned by the trust as if it's a separate tax-paying entity. Trust income is taxed at the highest tax bracket applicable to individuals as soon as there is over $12,950 of income. So in some cases, a trust can be drafted to provide that the tax consequences pass through to the beneficiary and are taxed at his or her rates. Typically our children are taxed at a lower rate because potentially they're younger, they're making less income. But we will often do this when creating a lifetime asset protection trust for a beneficiary. Some of the asset protection trust that we design for our clients is that we design lifetime asset protection trusts for the children, that the trust can provide the benefits of credit protection from lawsuits, from divorce, and I'm talking about the children divorce, or even their own bankruptcy. And it does not have the negative tax consequences of the highest tax rates, when you're making little income. So of course, if you have a trust and you want us to review it for the income tax consequences to your loved ones, after your death, please contact us. You can meet with our CPA tax lawyers that can um, discuss this with you in more details. And we're gonna have another webinar that specifically talks about lifetime asset protection trust, how to inherit, basically, how do you want your children to receive your inheritance? Because you can give it to them outright, but the issue with this that it's not protected from creditors, lawsuits, it's not protected from their own divorce. So the better option, the more advanced option is to give the inheritance in a lifetime asset protection trust, which is an irrevocable trust that the children would receive in their own trust. Each child will receive in their own trust, and it protects the children, God forbid, in the event of a car accident, you know, if they get in a car accident in the future and they have an inheritance that has been, let's say, transferred outright to them, so they have it in their bank accounts, it's easy for creditors to go after this inheritance because it's in their bank accounts. They can freeze these assets. Now, if they receive it in an irrevocable trust, because it's a separate entity, because the resource or the source of these funds come from the parents, so it is protected. It's shielded from any creditors. It's also shielded from their own divorce in the event of they get divorced. And we'll talk about it more specifically in another webinar. So now let's talk about estate taxes. And currently, if you die with assets over 11.58 million, then your estate will be subject to state tax and all amounts over that 11.58 million at the rate of 40%. Yep. So it's 40% will go to the government. If you have assets that exceeds the 11.58 million, if you're an individual, and almost 23.2 million for married couples. So obviously there's planning, advanced planning that you can do to mitigate these taxes or even eliminate them by using various planning methods, most of which are fairly complex, but worth it if you can save your family that 40% state tax. Do we have any questions so far, Sephora? I'm not sure, I'm not paying attention to.
Not yet, but I would encourage anyone that does have questions to please type it in the question and answer section and we'll get to them. Anything you want to know about trusts.
Okay, thank you. So, I'm going to just keep going. So if you're trying to figure out whether an irrevocable trust or a revocable trust or even a lifetime asset protection trust is best for you and your beneficiaries, our CPA tax associates as your family protection lawyers can help you evaluate that decision and make sure that you're making the right choice for yourself and the people that you love. So now we're going to move on, and I think, Sephora, you're going to take it from here. We're going to move on to the 6 cases when a trust is better than a will.
Right. So, okay. So 6 ways a trust is better than a will. So will is very basic estate planning document, and everyone should have one, for themselves, so that if something happens to you, we know how much and of your assets should go and to who it should go to. And there shouldn't be any questioning and conflict and stuff like that because it's all documented out. And, also in a will, you can also list what you want to happen to your kids and who they should go to, who you trust to take care of them, and then also provide for them in your trust, in your will as well, monetarily. But there are some cases having a trust is probably more preferential than a will, and these are going to be 6 ways. So one is to avoid probate, which Hani talked about, and probate, he mentioned is very time consuming, so it really doesn't make for a smooth transition. You'll be in and out of court, you'll be extending court dates, different things will be happening, and then finally at the end of, if it's very fast, it will be 9 months, or it can take up to 18 months until you finally see those assets coming to your beneficiaries. And then on top of that, it's very expensive. And so that's what we said. I mean, as a lawyer, you will either be being paid during somebody's probate, or you can be paid for making an estate plan for them that avoids that probate, which is 10% less on average than the actual statutory fees for carrying out a probate, actually. So the thing is, like, eventually you're going to be giving lawyers something and, you know, making your trust and making it according to what you want is a lot more, you know, economical, and it's, you know, much smarter because you're doing it your way rather than the state, allowing the state to distribute it the way that they think is proper. So we would avoid probate or conservatorship in case of a incapacity. And then, you know, so the trust bypasses the probate process, saves time and money, carries out instructions. Your will instructions will still be carried out. And so that's one of the ways that it's more beneficial. Next is providing for a person with special needs. So if you have any members of your family with special needs, there's a trust commonly known as a special needs trust. And so if you're receiving some type of government benefits and you want to give money to this child or family member, and you're worried that the benefits will stop, the special needs trust really provides a protection against that. So anything in that trust will not affect any qualification for government benefits. And so they won't lose any extra assets. Next is privacy. And so a will, because a will goes through probate, it becomes a public record. So the reason it does that is because the state wants to allow any kind of creditors to come and claim any outstanding balances or, you know, things like that. So to make sure all your debts are paid. But the problem with that is that it also opens up your information to scammers. It opens up your information to just nosy people, whatever, but like they can use that to see like what's happened, how much is left, how can I come in and try to claim something, you know. So the privacy part is actually very important part that we don't think about. Can we go back to the, yeah. And then blended families. So if you're part of a blended family, a trust can give you the flexibility you want to make sure that your children receive all the assets. There might be children from prior marriages or children from marriages that might happen in the future. And so you want to make sure that, you know, everybody's provided for in the way that you intend. And then out-of-state properties are just, you know, probating would just, you know, they would have to find these out-of-state properties. They would, and sometimes they're not even listed in your documents, and it might just get overlooked. And then that just adds to, you know, the Department of Unclaimed Properties out there. So just having everything funded to the trust just really allows for a much smoother transition. And then asset protection. So there's always ways of designing your trust that you leave behind to your loved ones that can protect them from creditors, including bankruptcy and divorce. And it can just give your loved ones what they could not easily always, you know, give themselves, which is just protection from creditors and stuff. So those are the 6 ways trusts is, you know, are considered better than wills. And like I said, if there's any questions because, you know, didn't understand that, or like you just have some questions, you guys can please post them. That way we can get to them.
Yeah, so really, if you want to learn more about the use of trust to pass on what you care about to the people that you love, you can call our offices today and schedule a time for us to sit down and talk. We normally charge $500 for a family wealth planning session, but we actually basically are waiving this fee. And because of this planning is so important, we actually made a space for the next 5 people who mentioned this webinar and schedule a meeting with us, basically to sit down with us where they can do a family wealth planning session at no charge. One of the things that we do is also go over a family wealth inventory assets, as I mentioned, where you can basically inventory all your assets to make sure that your family knows exactly about all these assets and avoid any of your assets being taken by the government or end up in the hands of the government because, you know, somebody missed the real estate property or a retirement account or a bank account. So it's a very important process that we get you more financially organized than inshallah ever before. And any questions, Sephora, that you have in the chat box, or we're good? Today is going to be a short one. We just kind of wanted to give the focus more on the trust aspect of it.
Right. I just have one thing to point out. It says first 5 people, but there's only 4 people there.
Okay.
On the slide.
Okay, sounds good.
Okay, so that's about it. These are our contact information. So you can email us at info@Cornerstone Law Services. You can check out our website at cornerstonelawservices.com or give us a call. And thank you so much for joining us today. And next time we'll probably be discussing lifetime asset protection trusts and how to structure it so that you can save on taxes and also protect your loved ones from court and conflict. Thank you.
Thank you.
You're the reason my life's worth living. You're the reason I'm alive. I'd be lost without you. You're the reason that I strive. You're my destiny. You're my reverie. You're the reason that I breathe. You are all that I believe.